Okay, welcome back, everyone. This is going to be part 2 of the Chapter 13 lecture on the courtroom, the pretrial and trial process. And if you recall, we finished up discussing the arraignment, and we talked a lot about the grand jury, and now we're going to take a look at some pretrial motions. So there are several pretrial motions that may be filed by a defense attorney, and these requests can profoundly impact the outcome of a defendant's case. So let's take a quick look at each one of these. So we'll talk briefly about double jeopardy, speedy trial, change of venue, discovery, and then finally suppression of evidence. So the first one we're going to look at is double jeopardy. Now, the Fifth Amendment to the U.S. Constitution provides that no person, and that's exactly what it says, shall be subject for the same offense to be twice put in jeopardy of life or limb. And this clause appears in most state constitutions and has been incorporated by the U.S. Supreme Court into the 14th Amendment Due Process Clause. So the notion that an individual may not be prosecuted more than once for the same offense or punished more than once for the same crime has been a feature of the legal system that form the foundation of modern American law. Now, the U.S. Supreme Court has held that the prohibition against double jeopardy involves 3 constitutional protections. The first is protection against a second prosecution for the same offense following an acquittal. Number 2, protection against a second prosecution for the same offense following a conviction. And number 3, protection against multiple punishments for the same offense. And so why is the prohibition against double jeopardy considered fundamental to the concept of justice? Well, a good argument can be made that there is nothing unfair about subjecting a person to multiple trials in an effort to obtain a criminal, conviction, or in order to remove a dangerous person from society. Now, in the case States versus DeFrancisco, the U.S. Supreme Court discussed various interests protected by the prohibition against double jeopardy. One is the finality of judgments. So a court trial verdict of not guilty should be respected and should not be modified in a second trial. Number 2, prosecutorial abuse. Number 3, individual security. And then finally, the last one would be punishment. So again, you can see the issues relating to double jeopardy. Well, what about speedy trial? So that was number 2 on our list. So the Sixth Amendment to the U.S. Constitution provides that in all criminal prosecutions, the accused shall enjoy the right to a speedy trial. And the 14th Amendment Due Process Clause incorporates the right to a speedy trial, which also is guaranteed by law in each of the 50 states. Now, scholars also point to the English Magna Carta of 1215, of one of the most famous human rights documents in history, as the first clear statement of the right to a speedy trial. And the U.S. Supreme Court has long recognized the history of the right to a speedy trial and its reception in this country clearly established that it is one of the basic rights preserved by our Constitution. Now, in a case, and one of the cases that gives us a little bit of information and talks about how this is one of the basic rights is the case of Klopfer versus North Carolina. But in a second case, Smith versus Huey, the U.S. Supreme Court identified 3 individual interests protected by the right to a speedy trial. And the first is incarceration, meaning a lengthy incarceration prior to trial results in or can result in unnecessary hardship. Next would be public accusation. An individual who is released on bail for a lengthy period while waiting for trial may be the subject of public criticism and isolation, etc. And then finally, preparation for trial. Incarceration does interfere with a person's ability to prepare for trial. And also a lengthy delay, think about this, could result in witnesses moving away, leaving the area, disappearing, or even passing away. So you have to kind of, think about that. And finally, one other case in Barker versus Wingo. The U.S. Supreme Court argued that there is a societal interest also in speedy trials. And think about what that could be. So the court identified a couple of things for us to think about. The first would be backlog. The failure to provide for swift trials leads to a backlog of cases and places pressure on the prosecutors to either drop charges, reduce sentences, or plea bargains, which is an acceptable thing to do. Next would be bail. The longer a person must wait to stand trial, the greater responsibility that the individual who is released on bail might jump bail or might not even come back to court. Next would be crime. An individual who is released for a lengthy period prior to trial may commit additional crimes that, think about it, could it be used against them? And then finally, incarceration. Those who are incarcerated for a lengthy period of time prior to trial may deteriorate psychologically and ultimately develop resentments that may interfere with their rehabilitation. So these are just a couple of things that kind of come to the forefront. Okay, so next on the list was change of venue. And this is kind of an interesting one. So Article 3, Section 2 of the U.S. Constitution originally required that jury trials for federal cases were to be held in the state where the crime was to have been committed. And one criticism was that the accused would not be tried by a jury of what they call vicinage, which also means the community in which the crime was committed. So as a result, the Sixth Amendment was amended to require a trial by an impartial jury of the state and district where the crime has occurred. So again, that phrase, vicinage, refers to the selection of a jury from the community in which the crime was committed. And that kind of makes sense, right? So as it relates to change of venue, the physical location of the judicial district in which the prosecution is to occur is called the venue. Now, in one particular case, in a case called Gropey versus Wisconsin, the U.S. Supreme Court held that a state is required to allow a change of venue or location, all right, in those instances where a defendant demonstrates to the court that a fair trial just can't be achieved. And think about some of the high-profile cases that have been out there. And why would you want to file for a change of venue? And the answer is, again, the defendant does not think that they can get a fair trial, let's say, due to media coverage. So look at the OJ case. And that was in downtown Los Angeles. I don't believe if they applied for a change of venue, but perhaps, and I know they did in this case. So these are the individuals responsible for the Rodney King case. And if you remember, it was originally to be tried in downtown Los Angeles, but the case was moved to Simi Valley because the individuals did not believe that they would be able to obtain a fair trial in Los Angeles. You could even think of another high-profile case like the Cosby case. So all of these. So just kind of in summary, the Supreme Court has held that a change of venue is required where the totality of circumstances indicates that any potential jurors are so influenced by all of the pretrial hoopla or publicity that they are not able to act impartial and decide a case just based on the evidence that's going to be presented. And some of the factors that the courts will look at will be, number one, that there is a persistent and widespread publicity regarding the case immediately prior to the trial and during the selection of the jury. Number two, the publicity describes the crimes in detail and assumes the defendant's guilt, so they've already assumed it. Number three, a significant percentage of the community is exposed to the publicity, so everybody already knows about it. Number four, a high percentage of the jury pool is aware of the case and they already have an opinion. And then number five, individuals selected for the jury express a inability to objectively evaluate the case, or the publicity is so persistent and so widespread that the court is unwilling to accept that the person or persons are able to objectively evaluate a case. And that is, again, why you may want to request a change of venue. Another one would be, or another pretrial motion would be that of discovery. So trials in the United States until about the late 20th century were kind of conducted or based on ambush and surprise. And here the prosecution and defense would enter the courtroom with a limited ability to basically predict the evidence that the other side might present at trial. Now, in 1963, in the case of Brady versus Maryland, the U.S. Supreme Court held that the Due Process Clause requires prosecutors when requested by the defense to disclose exonerating evidence, or the technical term is exculpatory, within their possession that is relevant to the innocence or sentence of the accused. And so the purpose of the Brady rule, or this Brady case, this Brady versus Maryland, is basically to prevent any type of miscarriage of justice. And that kind of makes sense, right? So in this particular case in Brady, the prosecution withheld a co-conspirator's admission that he had committed the actual killing. And this information would not have led directly, let's say, to Brady's acquittal, but the court determined that he was treated unfairly because of the evidence might have been used by Brady's attorney to argue that he did not deserve the death penalty. So the U.S. Supreme Court, in other cases, has found an obligation on the part of the government to turn over statements to the defense that raise questions regarding the truthfulness of witness testimony. So basically, any of that exculpatory evidence or exonerating evidence needs to be turned over. And that kind of wraps up the Brady case. So just to kind of finish up, the constitutional requirement to hand over exculpatory information is binding on both state and federal prosecutors. And state statutes and state rules of procedure take varying positions on disclosure of other evidence, ranging from virtually no disclosure to complete disclosure. Now, Rule 16 of the Federal Rules of Criminal Procedure addresses disclosure in federal courts. and several examples of state and federal approaches to discovery we're going to kind of talk about really quick. So a couple might be names and addresses of witnesses. Next could be witness statements, and then finally police officers. So most jurisdictions provide for the disclosure of medical and physical examinations and scientific tests, documents and tangible objects, and statements made by the accused. So again, this is kind of far-reaching when you talk about this Brady rule. Okay, one of the other things that we were going to talk about would be suppression of evidence, and I think that might be the last one on our list. So as previously discussed, evidence obtained in violation of the Fourth Amendment may be suppressed and excluded from evidence. We talked about that in Chapter 10. And confessions that are obtained in violation of the Fifth Amendment, the Miranda requirement, which was back in Chapter 8, and identifications that are obtained in violation of the Fifth and Sixth Amendment, which we talked about in Chapter 9, may also be suppressed. So now we're going to kind of look at the trial process and the right to a jury trial. So again, these are all issues as it relates to suppression evidence. And here, even in these high profile cases, so you can see here when this case started, this is the Simpson case. There was some issues reference a disputed search, and the lawyers wanted to exclude the evidence. So again, these are all pre-trial motions, whether you're going to exclude statements or evidence or what have you. Okay, so moving right along, because we need to push through so we can finish. We have a lot to cover still. Article 3, Section 2 of the U.S. Constitution talks about the trial of all crimes, except impeachment, shall be by a jury. So the Sixth Amendment to the U.S. Constitution, as we've said before, provides that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein or where the crime is said to have been committed. And the right to a jury trial is guaranteed by law in all 50 states, and 10 state constitutions guarantee a trial by jury for all criminal offenses. And without going through all of these cases, but in your textbook on 492 and 493, there is the Duncan versus Louisiana case, which is where the Supreme Court held that a right to jury trial in serious criminal cases is fundamental. Then there's the Baldwin versus New York case, where the Supreme Court held that a New York City ordinance that prohibited jury trials in crimes with penalties punishable by up to 1 year in prison was unconstitutional. And then there's the Blanton versus City of North Las Vegas case. And then there's the Lewis versus United case. And all of these deal directly with the constitutional right to a jury trial. But for jury trials, remember we initially kind of started off the conversation about the jury requirement, or how many people. So this is always the part that kind of interests me. So in Thompson versus Utah, the Supreme Court held that the Sixth Amendment follows the common law application and guarantees an individual a jury composed of 12 persons, neither more nor less. Now, in federal court. So again, this is kind of interesting. So now we've got a federal requirement in Thompson versus Utah. But then there's a case, Williams versus Florida, says that, or encompasses the fact that states are not required to use 12-member juries. Case of Bailu versus Georgia says that, 6 is okay, but 5 is too few. And the U.S. Supreme Court, though, at the end of the day, has also said that, no lower than 6. You guys, the 6-person jury is, sufficiently large enough to represent a cross-section of the community and to ensure a lively debate among competing points of view and to resist any outside influence. So again, how many do we use in California? If you remember. So I don't have time to play the videos. I'll have you kind of look at that. But in California, we use 12. And the other question I'm going to ask you is, do all 12 have to agree? So, interesting. And the answer is that yes. Now, some states don't say that all 12 have to agree, but in California, it's different. All 12 have to agree. And some of these cases, if you want to look them up, you can find them in your textbook. But I want to kind of keep moving on the jury selection portion. So the actual jury pool itself is called a veneer or master list or master jury list, from which a panel is to be selected and is typically based on names drawn from voter registration, either tax rolls or tax lists or driver's licenses of those that are over 18. And some other basic guidelines would be random selection. Individuals are to be selected in a random fashion. And typically, if I recall, I'm thinking back, I usually get a jury summons about once a year. The next one would be discrimination. Individuals shall not be excluded from service based on race, color, religion, sex, national origin, or economic status. And it needs to be a fair cross-section. So the individuals who are called to serve on the jury should reflect a cross-section of the community. And then finally, exemption. Various individuals are ineligible to serve on a jury, and this includes could be non-citizens, individuals less than 18 years old, so they're minors, individuals who are unable to read or write or understand and speak English, although there are interpreters, individuals whose mental or physical condition prevents their service, convicted felons, and various states exempt law enforcement officers, firefighters, and other individuals who serve in a vital public function. And what do you think that's for? So my wife, just to let you know, she is a deputy director for Children and Family Services, and she is extremely intelligent. She has 2 master's degrees, and I consider her to be extremely above board, and I think she could sit on any type of jury. But when the last time she went, she got all the way to jury selection, and under voir dire, when we'll learn about that in a few minutes, where they ask you certain questions. One of the questions was, do you know anyone in law enforcement? And when she replied yes, she was very kindly excused. And I'll let you kind of think about why. Because maybe, even though I believe she could be objective, the defense attorney may not believe that, and maybe even the prosecutor may not believe that. So those are some, and we'll kind of look at some other things that play into that. But that's the jury selection. So if you can serve, there are some terms that are applicable. So individuals who are called for jury service appear at the courthouse, and they are randomly assigned, typically by a number, to courtrooms. And the questioning of individuals to basically determine who is to serve on the jury is called voir dire. Remember, I gave you the example of my wife being questioned. Or it also means to speak the truth. So, kind of interesting. So there are a couple of challenges, which makes the jury selection process kind of interesting. because as you may have watched or read some of the information in your chapter introduction, there is and sometimes seems to be kind of a science to jury selection. So the prosecutor and defense attorney may remove individuals from the jury pool based on what they call a preemptory challenge, meaning without offering any reason, or based on a challenge for cause, which means that it's based on some type of bias or something else. Now, a lawyer or an attorney is not required to offer a reason for exercising a preemptory challenge, but a challenge for cause does require a reason. And the grounds for a challenge for cause, again, are typically stated in a statute. And this basically or typically includes a prohibition against individuals serving on the jury who maybe have sat on the grand jury, or who are acquainted with the individual involved in the case, or who are related to a person on the case. So a defense attorney or a prosecutor may also strike an individual for cause when the attorney satisfies the judge that an individual can't be fair. So that's the bias part. Or when a person's background or experience indicates that they are likely that they won't be impartial, or maybe they have some kind of implicit bias. Perhaps like in my wife's case, because she knows so many law enforcement officers that she might side with them. Does that make sense? So again, preemptory challenge, you may remove a juror without any reason except for race. Okay, but otherwise, if you don't think that they're going to suit the characteristics of the jury that you want, you can have them removed, and I'll show you the scientific factor in a minute. And then challenge for cause, okay, is for bias or prejudice. And the case referring to a preemptory challenge by race, which you're not allowed to do, would be the Batson versus Kentucky case. So a little bit more for California. So the law lets the judge and the attorneys excuse individual jurors from service, again, for various reasons. If a lawyer wants to have a juror excused, he must use a challenge to excuse the juror, and we talked about that. Challenges, even in California, they're either for cause or preemptory, but here's the kicker. There's a number. So there are unlimited challenge for cause, meaning that bias, or they know the people on the case, etc. But there's only 10 for preemptory challenges, meaning you just don't like the way that the vibe this person's giving off. Now, in criminal cases, there's going to be more, and in civil cases, there might be less. But in a typical jury trial, so you have to be strategic, right, about how you apply your preemptory challenges, because you only are allowed so many. Otherwise, because then you would just be rejecting everybody until you had everything perfect, and that's never going to happen. So the laws, the legislators and the procedural laws, they had to set some type of number. So there you have the numbers for California. And a little bit more, the U.S. Supreme Court states that the jury, again, is to be a cross-section of the community. So, and this is, there's a couple of cases that go with this, and the one that I'm kind of looking for, I believe it's Glasser versus United States. So, in this case, Glasser versus United States, the court held that the Sixth Amendment requirement that a federal jury be drawn from a fair cross-section of the community in which a crime has been committed, and this also applies to the states. But there are at least 4 reasons. One would be for decision making, and common sense judgment of a cross section of the community. So the jury should represent that cross section so they can get different thought processes. And this protects the defendant from the overzealous prosecutor or any type of bias, right? Next would be an impartial jury. So the fair cross-section requirement prevents the government from either stacking or packing the jury with pro-prosecution jurors. And it ensures that neither the prosecution nor the defense have an undue advantage. Next would be fairness. The appearance of unfairness needs to be avoided. So that's another reason. And then finally, civil rights. The right of historically disadvantaged groups to exercise their political rights and to serve on juries needs to be safeguarded. So again, the Supreme Court articulated this along with some tests to ensure the cross-section portion, and we'll talk about that in just a second. So if you've never served on a jury or even got a jury summons, if you want to look a little bit more about jury duty, you can click on this link and it'll take you there and you can kind of take a peek at it. So with that being said, what are some challenges to the judges? What do you see as challenges? We've talked about a lot of stuff, right? We've talked about all these preemptory challenges, whether it's from the juries or all the other sections that I kind of talked about. And keep in mind, one last thing regarding voir dire, the fact that a jury pool is created in a non-discriminatory fashion and reflects a cross-section of the community does not guarantee that every member in the jury pool, the veneer, is willing and able to fairly and objectively weigh and balance the evidence at a trial. And the Supreme Court has recognized that voir dire is of the utmost importance to ensuring the protection of a criminal defendant's Sixth Amendment right to an impartial jury. So the voir dire process involves questioning the potential jurors, again, to determine whether they should be excluded for cause or whether the lawyer should exercise their preemptory challenge and exclude them without cause in that preemptory fashion. Keep in mind that lawyers also use voir dire to establish a connection with potential jurors. Again, there's this whole kind of science. But back to the judges, what are some of their challenges? And there could be several, but the Fifth and the 14th Amendment's due process clause guarantees that a defendant will be tried before a neutral and impartial judge. The federal challenge for cause rule or statute, as well as state statutes and rules of criminal procedure, typically permit an attorney to file a motion to remove a judge from a case based on demonstration, which means some facts, that a judge might be biased. And do you think that that has ever happened? And this may arise where there is a close, let's say maybe friendship between the judge and an attorney, or between the judge and even a defendant. And a judge may also have a financial interest in the outcome of a case. So all of these things we need to, kind of at least understand the challenges for the judges as well. And one kind of definition that you need to know is called recusal. And this is the act of abstaining from participating in an official action or a case or a legal proceeding because perhaps maybe the judge does know someone or they have an interest in the case. And if they do, they are typically required to abstain, which mean, or recuse themselves, which means that they'll have somebody else hear the case to keep the process fair. And I'm pretty sure that that would make sense to anybody. Okay, so we've talked now about jury selection. Well, what about the actual trial? So the Sixth Amendment to the U.S. Constitution provides, again, that in all criminal prosecution, the accused shall enjoy the right to a public trial. Why public? That's kind of interesting. You know, this right is recognized as the central component of due process and was one of the first rights incorporated into the 14th Amendment. The right to a public trial applies, 1, to hearings related to the trial, including the preliminary hearings, pre-trial suspension hearings, the jury selection, the issuing of jury instructions, and sentencing hearings, and 2, to all phases of the trial that have a reasonably substantial relationship to the defendant's defense against the criminal charges. So, public trial. And have you ever noticed, if you go to one of the courthouses, if you go to your local courthouse, you can actually sit in on a trial. So, I mean, because it's public. So the requirement of a public trial is designed to protect defendants from being subjected to so-called secret trials, in which the government takes advantage of the lack of public scrutiny regarding the accused. In another case, the Waller versus Georgia case, the Supreme Court listed other benefits of public trials. So just really quick, one would be fairness. Makes sense. One would be a witness, meaning a public trial draws attention to the case. And it could result in witnesses coming forward to offer evidence. And then the last one would be truthfulness, because witnesses are aware that the truthfulness of their testimony is going to be evaluated by the public. So again, this public trial, central component of due process, it applies to almost all of the hearings related to the trial. It's designed to protect defendants from being subjected to these secret trials. Press and the public, we have to keep this in mind, could be excluded from a preliminary hearing where there is a substantial probability that the publicity, remember we talked about publicity, might prejudice the defendant's right to a fair trial, and there are no reasonable alternatives to closing the hearing. And proceedings may also be closed to protect juveniles alleged to have been involved or been victims of sexual abuse. So those are some of the rationales regarding a public trial. So now, what about the trial itself? Well, the defendant now enters the formal trial stage of the criminal justice process. And the same theme of balancing societal interests in criminal prosecution against the interest in protecting the rights of the defendant is evident in the procedures at a trial. So first you would have the opening statement, and this is a brief verbal presentation of the evidence that a lawyer plans to present. And typically it's the prosecution, but the opening statements, they'll both do them, but the prosecution and defense each outline their case. And lawyers are not to refer to the evidence reasonably believed to be inadmissible later on, and they should not be used to make an impassionate argument or emotional appeal in the opening statement. This is kind of an outline of their case. Here is kind of some summarized or short videos on the Fred Mueller murder case. It's a great case where a husband and wife go up to the top of this hill with their dog, and at some point the woman slips off the hill and falls into the creek, and she is killed. and he is prosecuted, and you'll see a portion of the opening statement by the prosecution and the defense. So these are a couple of good videos to watch. Next would be the presentation of evidence, or what they call the case in chief. And this is presented by the prosecution first. So the prosecution, has the burden of proving the elements of the crime beyond a reasonable doubt. And they may use witnesses, documents, scientific tests, and other physical evidence. And that's kind of the opening part. And part of this is cross-examination by defense counsel, asking questions of those who testify to raise questions about the accuracy and credibility of their testimony. And then there is rebuttal, and this is the main case by the defense. So prosecution goes first, does all their stuff, as I said, and then they rest, and the defense will do the exact same thing. And of course, the prosecution can cross-examine the defense, witnesses, etc. And one important piece here is the Sixth Amendment, which incorporates the confrontation clause, which is the right to be present and confront witnesses and evidence against the accused. And this is based on a concern with ensuring the accuracy of trials, requiring witnesses to appear in court and testify under oath, and to be cross-examined. And the issue of, let's say, sexual molestation of juveniles, it is okay to have juveniles that are victims of sex crimes, or I ask a question, is it okay? Sometimes it is, and sometimes we don't. But again, typically, sometimes we'll do it by closed circuit TV because the juveniles are so stressed out, and then sometimes we'll basically we'll have them testify. It really does kind of depend. And again, remember the confrontation portion. Two of the most interesting confrontation clauses involve juveniles alleged to have been sexually molested. The issue when it comes to the confrontation clause in Maryland versus Craig is whether the defendants had the absolute right to confront face-to-face the witnesses. So if you're a defendant and you are alleged of doing something to a minor, can you force the minor to be in court, to be face-to-face with the witnesses against you? And I'll just kind of let that sit. And the answer to that is it kind of depends. So, and you can look at the Maryland versus Craig case. We talked a little bit about cross-examination. An attorney in judicial law, John Henry Wigmore, said it like this: the greatest contribution of common law and the greatest legal engine ever invented for the discovery of the truth is cross-examination. Because when you cross-examine is to determine whether a witness's testimony can withstand questioning that probes the witness's accuracy, consistency, and objectivity. So that's the need for cross-examination. But of course, as we've talked about, sometimes with juveniles it's a little bit different. And then finally, hearsay. Rule 801 of the Federal Rules of Evidence defines hearsay as a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. So this is basically a witness testifying as to what someone else said outside of the courtroom. And typically hearsay violates the confrontation clause, the one that we looked at, where a confrontation clause says that, you should be allowed to confront everybody, but sometimes with juveniles, maybe not. All right. But while it violates that confrontation clause, in certain circumstances, very limited circumstances, it is allowed. So I'm not going to give you all of those circumstances. You can find a little bit more on page 512, but I wanted to let you know that sometimes hearsay is acceptable. And then finally, the compulsory process of trials. So again, the Sixth Amendment that we're kind of talking about, an individual shall have the compulsory process for obtaining witnesses in their favor, meaning the subpoena power of the court, right? The defendant has the right to bring in or obtain witnesses, documents, and other evidence that are required to defend him or herself. And the defendant has the right to also present witnesses and documents and other evidence at trial to present their criminal defense. And a couple of cases, one is Rock versus Arkansas, where the court held that a rule automatically excluding all hypnotically refreshed memory testimony is impermissible. So, I mean, these are kind of weird cases, but again, you shouldn't automatically exclude everything. In a case, Chambers versus Mississippi here, the court held that the trial court's refusal to permit 3 witnesses to testify that another individual had told each of them he committed the crime was impermissible. So again, you've got some different circumstances here. And if you've never seen what a subpoena looks like, this would be an actual subpoena. And this is one that was issued in Florida. So you can kind of see what a subpoena looks like. So what about the burden of proof? And we're just about done here. The burden of proof. Trials in the American criminal justice system, as I've said before, they are adversarial. And the adversarial process involves a courtroom, kind of a clash, if you will, between a prosecutor representing the government and the defense attorney representing the defendant, and each is expected to represent his or her client and is responsible for presenting the law and facts to the best of their ability that favor his or her client. So hopefully that kind of makes sense. And the burden of proof is the standard that must be satisfied for a criminal conviction. So the burden of proof has 2 components. First, the burden of going forward, or what we call the burden of production. And second, the burden of persuasion. So the burden of persuasion is proving the defendant's guilt beyond a reasonable doubt. And yes, the defense's job is to show doubt to the jury, but both of these usually fall a little bit on the prosecution side, if that kind of makes sense. So a criminal conviction carries very serious consequences, and that the government must bear the burden of criminally convicting an individual and depriving them of his or her liberty, which is why the burden for conviction tends to fall on the prosecution. Because remember, the Fifth Amendment says no person shall be compelled in any criminal case to be a witness against themselves. So the defense is in no way required to even help the prosecution, if that makes sense as well. So kind of an interesting thing. And a case that really set the stage for conviction, or this beyond a reasonable doubt, is the In re Winship case. And in re Winship, the U.S. Supreme Court held that the beyond a reasonable doubt standard has been a requirement of common law at least since 1798, and is part of the defendant's right to due process. And the court proclaimed that the Due Process Clause protects the accused from conviction except beyond proof beyond a reasonable doubt of every fact necessary to constitute the crime with which he or she is charged. And there are several reasons for that. One is the presumption of innocence. The next would be false convictions. The next would be the seriousness of criminal conviction. And then, of course, community confidence. So, again, I kind of just went through those already, but these are the reasons for those high standards. So, again, closing arguments. So we've kind of walked through the whole process, if you will, And now we're just about there. We're at closing arguments. So following the presentation of evidence by the prosecutor and the defense, the attorneys will make closing arguments. The prosecutor goes first, and then the defense replies. Now, the prosecutor is also permitted to respond to the defense. And the thinking behind this arraignment or arrangement is that the prosecutor, again, bears the burden of proving guilt beyond a reasonable doubt and should be provided with the opportunity to rebut the defense's closing arguments. And the case that kind of talks about that, there are actually three of them, would be the Herring versus New York case, would be Dunlap versus United States, and then finally Donnelly versus De Cristoforo. And again, these are three cases that talk about the closing arguments. So again, closing arguments under the invited response doctrine, used to evaluate the impact of the prosecutor's remarks. Courts rarely reverse a conviction based on a prosecutor's closing remarks because some of the remarks, there are certain things that you can't say because the prosecutor and defense attorney are expected to adhere to the same standard of conduct in their closing statements. So trial courts tend to be more concerned about the conduct of prosecutors who possess a special responsibility as a representative of the government to ensure that their authority is exercised in a fair and just fashion and is not employed to abuse and to convict an innocent person. So the U.S. Supreme Court has stressed that while the lawyers should be given significant freedom in making their closing arguments, these arguments may be limited to ensure that the trial is orderly and fair. And some of those arguments are listed on page 519. And I think there you'll also see the information that falls under the Dunlap case as well. So I also have a couple of video clips for the George Zimmerman case if you want to look at that, and also the closing arguments of the O.J. Simpson case. And then I have a couple of funny videos on courtroom decorum. So what happens at the end, right before? So now everybody's done. Both sides have presented their case, and now we're at jury instructions. And instructions are issued to the jury by the judge before the jury begins to discuss the defendant's guilt or innocence. Now remember, the judge is the trier of law, and the jury is the trier of the facts. And people are presumed innocent until proven guilty, and the burden is on the prosecution to establish guilt beyond a reasonable doubt. And the jury is then explained or told the elements of the crime so they can make sure that they see or figure out whether the attorney has met the burden of those elements. And the judge will explain the procedures to be followed by the jury. And in most cases, there is a standard pattern of jury instructions that a jury will follow, or a judge will follow, And the attorneys have a little bit of say, but really not a lot of say in there. So I have a video for jury instructions if you want to look at it. And now it's time for deliberations where they're going to go back and talk. So jurors are ordinarily provided with copies of the charges and the jury instructions. And the judge may allow jurors to view some exhibits that were introduced into evidence and some phrases that you've heard. Deadlocked juries are those that are unable to reach a verdict. A hung jury is a jury that cannot reach a verdict after deliberating for a reasonable time. And a lot of times the judge might basically cite what they call the Allen case, or employ what they call a dynamite charge, which basically means go back, you tried for a little bit, maybe you were close, so go back and reconsider where you're at. And, if more for guilty, those not for it should reconsider whether your doubt is reasonable or whatever, but go back and try it again. But again, a deadlocked jury is one where you can't reach a verdict. A hung jury is just one that's kind of hung up. They can't reach a verdict after deliberating for a reasonable time. Now, this has changed. There has been a recent case, and I did not put it in here, and I'll probably send something out separately. But under the Sixth Amendment, right now we have 48 states that require a unanimous decision. And there's a couple of cases that have done this. And when we talk unanimous decision, they mean all the jurors have to agree. So there's a case, Apodaca versus Oregon, and states that the requirement of unanimous is not built into the 14th Amendment. Therefore, it was upheld on a 10-2 vote. And there's Johnson versus Louisiana that was upheld on a 9-3 vote. And there's Birch versus Louisiana that says a 6-person jury for misdemeanors, and that only 5 are needed to convict. So again, a couple of little, anomalies rolling around out there. But now, after a recent court case, it's all 50 states. There needs to be a unanimous decision in all jury convictions. Criminal convictions. A little bit on jury nullification. A jury verdict acquitting a defendant cannot be appealed. So if he's acquitted, you can't appeal. An acquittal ordinarily is based on the decision of a jury that the prosecutor failed to present the facts that establish the person's guilt beyond a reasonable doubt. And sometimes a jury may find that the prosecutor proved a person was guilty beyond a reasonable doubt and still did not return that verdict of guilty. And this situation comes about where the jury believes that the law might be unfair, or the circumstances, like to acquit a husband or wife who killed, let's say, a dying elderly spouse or an adult child who killed a parent who was in extreme pain, something like that. So I know it sounds a little bit funny, but sometimes the juries will kind of become emotional and attached to that. And even though the prosecutor was able to show all the elements beyond a reasonable doubt, there still may not be a conviction. And this kind of is basically saying that the juries vote their conscience rather than the law. And then finally, pleas. So plea bargains, really quick. This is where a defendant agrees to plead guilty in return for a benefit. And one of the benefits could be a reduction or dismissal of some of the charges, maybe a reduction of a sentence or time, or maybe a sentencing recommendation where the prosecutor agrees not to oppose the defendant's request for a specific sentence. So sometimes you'll see the plea bargain come in there. And as it relates to plea bargains and guilty pleas, the American Bar Association lists 4 considerations. One is responsibility, meaning the defendant is taking responsibility. Next is flexibility, where the judge can use creative sentencing. Victims, not subjecting victims to a trial. And then cooperation, the defendant may too agree to cooperate with other investigations. Again, we talked about plea bargaining. A defendant who enters a plea bargain waives 3 very important rights. The Fifth Amendment, which is the right against self-incrimination, because if you plea bargain, you're going to plead guilty to whatever it is that you're going to plead to. The Sixth Amendment to a criminal trial, you're going to waive your right to a trial. And then the Sixth Amendment right to confront witnesses, you're going to waive all of that in order to take the plea. So hopefully that makes sense. There's also a standard that the judge must make sure the defendant understands when there's a plea bargain. That would be the nature of the criminal charges, meaning explain the charges to which the person is pleading to, making sure there's a factual basis of the plea, explain how these specific facts of the defendant's case fit the requirements of the criminal charge to which the defendant is pleading guilty. And then the plea must be voluntary, meaning freely and voluntary. So a lot of aspects to plea plea bargaining. Guilty pleas, there are some benefits. There's cost benefit, efficiency, finality, meaning closure. Maybe you might take a guilty plea, or you might allow a guilty plea because there's a weak case by the prosecution or a weak case by the defense. Some of the weaknesses would be disparity. Sometimes, those who plead guilty usually get less time. And is that really fair? Shouldn't they get the whole time? Innocent defendants, sometimes individuals will take a plea bargain or plead guilty to avoid the uncertainty of a trial, because if they go to trial, let's say it's a case where it's 20 years, but they're offered 8 years. So if they take the plea, they get out, and maybe they'll get out early, etc., with good time and parole. But if they go to a trial and they lose, then they could get the 20 years. So we really have to understand the dynamic of that. In administrative convenience, the attorneys are busy and they're trying to clear all this stuff out. And then I put in a trial verdict video as well, the same with the O.J. Simpson case. Okay, we squeezed in a lot of information on there, so I'm glad you were able to hang with me. But again, read some of the information, watch some of the videos. I think you'll find them helpful in adding a little bit of context, because we did have to kind of move through a lot of information. But with that said, this will complete our Part 2, Chapter 13 lecture on the courtroom, the pretrial and trial process. So until next time.